Cool.
Topic is the interpretation of rule means to rule directly opposite the earlier decision. Rule means authorities the person must encyclopedia dictionary on all five of the judicial decision of rule and later decision. The identification laws direct opposition to the earlier decision. And even if a new decision it dictates a different result in the old case, it doesn't overrule an old decision if its reasoning is on separate grounds. The question decided on the F was articulated in the old case, so there's no precedent to overrule. Stevens indicated reading the mission can't be conditioned to result. And the older Rigner case, the mention can't be kind of overruled regarding the point that Rigner did not decide. AB's violation of the plan creates a new precedent on an issue that was unrelated to what it decided in the original case. The only time will affirm to those that rule directly opposite to the original holding. And this is a voting issue wanting the grounding of predictability is determined by the conduct of the decisions allowing the affirmative screen to law and unrelated grounds means that we can't list the issues that decisions are about. We can't read procedural due process, bad stance against queer, and if you have rules on international law, for example, we can't read distinguished comments if you have rules on facts unrelated to the original case. And two is limits, they literally destroy the topic. A's some questions of the decision. In every case, relies crucially on justice alignment precedent, statute 100, decision, legitimacy of judicial review, statute 100, and allowing to reach and to way back destroys any semblance of limits. And B is the question plus in every decision is a set of questions that the court has to address. E.g. case protection, in the House and segregation, wars, and international law, queer citizenship, and these are only the tip of the iceberg, and constitutional debate is an infinite universal possibilities. We should focus on likely outcomes and concrete cases to achieve its benefits. Evel 92. Even if the Constitution is something infinite array of possible interpretation, only jobs for the most credible constitutional interpretation apply to the problem institution of the Constitution. This precisely where the debate should take place, but the meaningful range of interpretations that is more helpful and more relevant to the judiciary. And that's what we voting issue the interpretation overstretches our research burden and destroys our ability to engage firmly with in-depth legitimacy. Uniqueness, the Supreme Court adheres to a doctrine requiring special justification over precedent. This is the only way to maintain legitimacy sellers. And the providing precedent in a case of the court on the term relies the schools workable subsequent cases undermine the rationale of the decision. The court says actual precedents on whether the foundation of practice of precedent have been eroded by subsequent cases where the precedent have been subject to substantial criticism, whether there's been society reliant past holdings for the precedents would destroy the judicial practice. There would be no finality or stability in the law. The court system would be chaotic, acceleration, unstable, and inconsistent in its decision departure from the precedent requires special justification to justify the damage that they inevitably represent. Next argument is that the Robert Court is adhering to a precedent. The Economist in 1216 Robert's philosophy is that the insistence that the judicial activism interpreting the law rather than solving its problems. That the Robert's fears legal minimalism, predictability, percent cases that based on the rule of law may not be the future. The court saying few 40 that present the case in the last term opinions are more often unanimous. Some of these decisions concern issues whether court watches predictable fears battles the notably abortion, the death penalty, and religious freedom. Next argument is that the plan over rules the decision because it was decided wrongly. This would destroy the court's legitimacy and destroys the solvency. Allison and all three court rulers being communicated legitimacy can be protected only for the decision of over precedent received as an best on some special reason all relative to the belief that the practice was decided wrongly. It's well conservatives not surrender political pressure otherwise. The rule may not be presidential force the economy number result efforts to overturn and court legitimacy is vital to Moxie Levine and 97 more of the more ordinary citizen. I guess that's what getting judge's decision. The decision the court is not fair and under law. Our entire democracy will be lost. And the collapse of democracy was genocide and war around Rome. And 95 the groups of the cult system outside nearly 170 million people. The size of the degree which receives the power line, the democratic totalitarians and mentioned democracy don't make war on each other. The more democratic nations are, the less war and violence between them. The more democratic regime, the less internal violence. Count on. The United States Supreme Court issued in the next available case apply modified equal protection standard to the future abortion ruling that uses strict scrutiny and gender and suspect class recognizing the abortion restriction impact women is regardless of intent and ruled that the state has no compelling interest in protecting life. And the ruling on alternate grounds doesn't overrule the original decision, distinguishes it, but has the same legal effect as the plan. The counterplan alone is consistent with Sardi and 79 and Sardi says that the precedent they do overrule precedent making of the decision consistent with the principle of the Sardi says the court's not overruled it's not absolute justification even though it results in inconsistent with justifying rule of the precedent. And the counterplan legally can progressively expand abortion access without overruling Casey. In fact, will explicitly incorporate the anti-burden standard in the first test of abortion access early. And in 95, the court of Casey was applying the the scrutiny of the abortion rulings. There is no need to choose between the divorce of equal protection and house because abortion restrictions will play both the Casey profess to a commitment to reproductive rights and the commitment to liberty of the woman's soul and the opportunity to and citing because abortion may place both issues all laws access to abortion must be able to due process and equal protection because the court continues to the principle purpose to show how despite the evidence how to contemplate Casey that may be contained the chief of jurisprudence more consistent with and more responsible to people's test for secure reproductive rights. Casey is more important because represents new willing for the court to now try to readily affect one intent breaks women's lives and to recognize the abortion laws affecting women, including those not currently running the court teams, to recognize that because abortion laws affect women significantly more than such that the Constitution right to be protected on the basis of gender life should seize whatever opportunities the court presents and should use their advantage whenever progressive language the court provides, even though such language is obscured by progressive holdings. And the modified equal protection standard of the counterplan will progressively change the court's abortion jurisprudence to protect abortion access to women's rights and break down negative stereotypes of gender in the law. And 94, the court said that the modified version of the equal protection doctrine scrutinized more closely legislation negatively affects women and class revised equal protection analysis focused on practical effects of legislation that controls advantage abortion violating or equal protection guarantees that the scrutiny is not provided clear consistency of the standard of fulfilling adequately protect human rights from gender discrimination. The court is protecting legitimate equal protection for women and must acknowledge the gender system classification and then review the colonization affects women. The class of the court must recognize the gender classification system because the history of spirit women. The court must fully acknowledge that only women become pregnant and won't become parents abortion burden of childbearing. The court must recognize the regulation regarding health all women in class, regardless of whether they're seeking abortion services or not, have access to abortion as a class, the service that any woman is perpetuating gender stereotype of women readers, whose primary function is to very restrict gender stereotypes, measure by the legislature abortion and equally affect all women regardless of any level where they are capable of conceiving children, requiring a 24-hour waiting period for a woman to obtain an abortion applies to a woman who are capable of independently making a decision about whether they should be told to go home and sleep on. The court can examine what the state is going to do to women, not simply why it does it. Revise equal protection law, which considers generous to subsequent class and do emphasize the determined legislative requirement which gender protection from legislation and that person woman case way. At the time, you have to assess consequences. They maintain a moral stance. The stance of the Crusades would justify global intervention no matter what the cause of increase of global violence. To be ignoring the consequences justifies the existence of the monistic harm. In other words, you could say that you have a moral obligation to say about terrorism and ignore the consequences of loss of liberty. See, moral values can't be given meaning without looking at the consequences. They can't say that something is immoral without first assessing with the action and the impact. Indeed, this moral television is complicit with evil. They criticize Isaac and ultimately noting the moral good something is full of responsibility. Because the priorities one attention not should the children one attention subjects until evidence started view the mess serving and moral good began to capture this world is the world of real life, such as the moral purity is not some of the form of violence. It is often a form of felicity, justice bodies much not the consequences more intense effects of action rather than the motives of action. The most significant is often the pursuit of good that generates the pursuit of evil. And there's no substance for futurism. Futurism is no longer about sexual reproduction, but the existence of the future itself. You have nothing to undermine that. Fatal 5. The norms of reproductive narrative continue to saturate the moral imagination of biological reproduction in the circle of describing normal social norms have actually intensified whether we bear children or not in the lives and the coverage of the future. They continue to be imagined, not the activity of other adults like ourselves, but as the inheritance of children and rejecting it for reproductive futurism can't solve fantasies of immortality, fate, and 5. All aspects of human culture are concerned with immortality. Fantasies of immortality makes it outside the reproductive paradigm and earnings up to 5 vicarious immortality may not be reducible to heteronormative strategies of constellation and anime rejects all forms of political engagement and ignores the ability of politics to produce social change. He has rejection of compromise and powers of the Christian right recommend. And when he asserts that there is no creed to the future, they may prove no future for creeds. He's not making a brief statement of the purpose, but he's not saying theoretical position that he's supposed to save the entire argument. The burden of this argument is that generally a critical discourse cannot rise, making the existence of the other person in the future should know the political realms, meaning social reproduction, since that this serves the relative can't do even a world economic institution, but not simply a mechanism of social reproduction. Is also the same the instrument of social change, or specifically a field phrasing power relations, also the drain of conversation and the compromise motive elements analysis takes the rhetoric of the Andrew Christian right. You more several discourse on the level when it comes to understanding the underlying how sexuality and anything this is true on this kind of right. It's not a turn to source of the sense of symbolic order, but then the most radical, simply more reactive, and has mobilized with more significant goals. And turn is essential to psychoanalytic theories for us on universal assertion, shielding from any criticism and over applying to all specific scenarios of antagonism, recreating the symbolic war. They can criticize Robinson and war grassroots life is a myth that is asserts that the symbolistic fallacy of realistic moral reaching for argue for its assumptions. This is precisely the sense of the constitution of black is most practice was operated while the explanation of ontological views is an ontological message rejected side of control outside the context of sitting part of the counter theory and follows the priority of structural matrix, which is not open to change. Next argument is that most abortions are coerced by men. They sustain male control of sexual relations while and other abortion facilities, sexist practices that mothers who carry unborn children, abortions, reproductive technology facilities to the female body, and means of sexual coercion for men. Abortions are often as the BTS of male counterparts who do not want to limit the responsibility of father of financial obligation they want to come to the child. And abortion grants the medical is absolute control over women's decision making. It is a demeaning act that makes them passive. Often, abortion and reproductive medical technology increase the move away from the full decision making process. Specifically, presumably, women can never make such an important decision on her own. Such grants and language clearly means woman and seeks to reward them rhetorically, signaling such medical abortion industry and legalization and abortion will save the U.S. economy from collapsing, creates spending boom like and L5. Not only will Social Security be saved by ending abortion in the country, but the economy itself will equipment was by clothes and food, furniture, and other cities for the child. The advocates up to the 4 million children will be very veritable boon. There are also investments, life insurance, the real estate. They need to consider parents have to save for a house and more likely to buy a house. They need to have the economy, and then people don't. And U.S. economic climate is preemptive biological and nuclear wars that draw the other nation makes for ours. The end result is global Armageddon. Period. And the largest part of the cost of the economy WB will be used. Every one of fires out possible against the preceding enemies, so there will be Europe's bad ending, unleashed the language, special nuclear arsenals, and biological warfare arsenals should be filled the economic collapse that all the costs is certainly eventually drawn in the nation. And under the wars of the 11, we have a 99% chance of this scenario resulting in science and philosophy agree the fetus and human soul affect person from the time of fertilization. And 93, the human being is a person in later characteristics of rational attributes are only guides much for this, but logical evidence of sorts of human organization must be accounted for the presence of the human soul right from the beginning.
What's the impact to that argument?
Well, if you're killing people, then our utilitarian arguments would indicate that is bad.
Okay.
That's the last part, so you
Yeah. I would leave that.
Okay. Your legitimacy argument says that the court currently adheres to a special justification standard for allows overrules, essentially. I mean, have you read any evidence that indicates that I mean, why would the plan be a departure from a special justification? I mean, the requirements that are outlined in the Casey decision about overrule, for example, say that if the precedent has become unworkable, if it imposes, if it's inconsistent with equality standards given in the Constitution, et cetera, those are all reasons that overrule would be justified. Why wouldn't we just be in line with those special justifications that
Because
are
the
outlined?
ground by which you decide to overrule needs to incorporate that reason of special justification and unworkability. As of your 1AC plan text, it only indicates that the state.
So is your argument that it just needs to be in the plan, that we just need to like outline the special justification in the plan?
That the Supreme Court, in administering its overrule, needs to incorporate a special justification.
Sure, I just wonder, I mean, why implicitly is the app, just because it says that they don't have an interest in promoting potential life, why couldn't they say, it's,
Look, as of the
hold on,
1AC
they don't have an interest in promoting potential life because it oppresses women. I don't
As of your
understand why that's not
1AC
special
advocacy,
justification.
you have not incorporated a constitutional reason of special justification for the Supreme Court to overrule Casey.
The Casey decision doesn't say that anything about a constitutional special justification. It just says that there are certain reasons in certain instances where
Right.
they can say we were wrong. And some of those are that it oppresses people, that it betrays other rights that are given in the Constitution, that it's unworkable. My only question is why, when they said that you can't promote potential life, why couldn't that be in accordance with those standards?
It's just because if you were to overturn Casey on a random decision that is not actually in accordance with a special justification, it is not a legitimate overrule. You have not presented a reason as to how your decision is
So
actually
the
fitting with Casey standards.
counterplan text does what?
It essentially distinguishes.
It's just a distinguish argument? How do you distinguish Casey? I mean, what's the practical, so is the practical effect of the counterplan just that you eliminate, you don't get rid of the undue burden standard, you don't get rid of the state's ability
I mean, I need to look
promote
at the
potential life?
text again, but.
If you're in an equal protection doctrine that's based on abortion,
Why doesn't that link to all your legitimacy arguments? Why is the creation of an equal protection doctrine and its application to abortion, et cetera, why wouldn't that link to all your legitimacy?
first it's an alternate grounds, which means that it would be a distinguished counterplan.
So
All evidence specific to
Why does that link to your legitimacy args? I mean, your legitimacy args, I mean,
based on overruling.
well, I mean, your answer to us is that we created a constitutional standard that isn't in accordance with those special justifications. My
In
question
accordance
is
with
just,
an overrule,
I mean,
our
why would,
standards
hold
evidence
on,
is only
hold on.
specific to the act of overrule.
So it's only, so the court cannot look illegitimate in any other respects?
Not as of our Lincoln.
So what's the practical effect of the counterplan? What's the,
I mean, we argue that it solves the case. It
well,
doesn't-
does it just get rid of the restrictions that are legitimized?
Ready?
Okay. You've got like 9.5-ish left.
You back.